Assalamualaikum warahmatullahi wabarakatuh and good morning to Dr. Hana
Wassalamualaikum warahmatullahi wabarakatuh. Good morning.
and my fellow friends. So today our group, which is group 11, will be present on the activity tools of current issue. So next slide. In this presentation, we will summarize our case that we have chosen, which include the facts and also the issues, and then proceed with the relevant law involved with the sanction given by the court to the defendants of our case, and then suggestion and conclusion. Next. So basically, our group choose the case between Petra Perdana Berhad and also Petra Energy Berhad. So the facts here is that Petra Perdana Berhad is a majority shareholder to its subsidiary, which is Petra Energy Berhad. So Petra Perdana was a publicly traded investment holding company which owns 64% of the share of the Petra Energy Berhad. And in this case, there were actually three defendants that once a Petra Perdana's directors. So for the first defendant, he served as executive chairman and chief executive officer, which is Tengku Datuk Ibrahim Petra bin Tengku Indra Petra, while the second, which is Wong Fok Han and third Tiong Yong Kong, were the defendants that were once a non-executive directors. So next. So the issue arise here is that there is a dispute of a particular shareholders resolution of Petra Perdana. So for Petra Perdana to sell the PEB shares, the shareholders had voted for an ordinary resolution imposing the certain limitation on that the directors, which are the sales must made in cash and with the maximum of 10% discount. So this general mandate imposed by the shareholders were renewed annually by the shareholders in general meeting. But then Petra Perdana experienced some problem, which is the cash flow problems, which then lead to the directors to decide on selling part of PEB shares that the company owned. Even though the sale actually did not require any statutory approval of the shareholders, as it was not a substantial portion of the company asset, however, it still did not comply with the restrictions set out in the shareholders' mandate. Next. So eventually, due to that dispute at Petra Perdana, it led to the defendants that has been mentioned just now, the three defendants, being removed as the directors of the company. So the Petra Perdana later appoint the new directors. So with that new management in place, the company filed a suit against the now removed directors due to the breach of duty to act in the best interest of the company, acting dishonestly and conspiring to cause the company loss and damage. So I pass the next part to the next presenter.
Okay, I will present about the law involved in this case. So next. So the relevant law involved in this case is Section 211 under Companies Act 2016 stated that the power of the directors to manage the affairs and business of the company. In the Section 211 subsection 1, the business and affairs of a company shall be managed by or under the direction of the board, and the Section 211 subsection 2, the board has all the powers necessary for managing and directing and supervising the management of the business and affairs of the company, subject to any modification, exception, or limitation contained in this act or in the constitution of the company. In this case, there is a problem arise pertaining to the dynamics between the board of the director and the shareholders in general meeting. It was whether the director's ability to sell the PEB share could be limited or overridden by the shareholders' directive or not. Next is Section 213 subsection 1 stated about the director must exercise his power with proper purpose for the best interest of the company. A breach for this section may cause criminal offence and additional result in directors being liable for losses that are suffered by the company. Even if you are a owner of the company, you must put the company's need ahead of your own when you are a director. So in this case, there is problem arise where the director did not act in the best in company best interest as the shareholders feel that the act of selling shares violate the agreement and mandate that they made and the transaction were not advantageous to the firm. Right? Other than that is section 213 subsection 2. As stated above, director shall exercise reasonable care, skill and diligence with the knowledge, skill and experience which may reasonably be expected of a director having the same responsibilities and any additional knowledge, skill and experience which the director in fact has. In this case, the director being sued because they believe that the director will not carry their duties properly and will only bring loss to the company if they sold the part of the share. So the last section involved is section 214 subsection 1, which stated that the business judgment rule, which explained that the director who makes a business judgment is deemed to meet the requirements of the duty under subsection 213 subsection 2 and, and the equivalent duties under the common law and equity if the director make a business judgment for a proper purpose and in good faith. B, does not have a material personal interest in the subject matter of the business judgment. C is informed about the subject matter of the business judgment to the extent the director reasonably believed to be appropriate under the circumstances, and D reasonably believe that the business judgment is in the best interest of the company. And if the specific prerequisites are met, this rule will be used and assume that the director behave with reasonable care and skill in managing the business. Next. And for the sanction given, for the summary of this case is the three directors were accused for breach of duty to act in the best interest of the company and acting dishonestly and conspiring to cause the company loss and damage from their shareholders. However, the federal court held that the shareholders in the general meeting may not usurp the power of management conferred by the Article of Association (AA) on the board of directors of the company. Shareholders may only assert their powers over the board of directors by altering the AA to take away the powers of the director whose action they disapprove or remove the director concerned. According to the federal court, a board of director management functions are granted by the constitution to it. Therefore, the shareholders cannot control them in the general meeting. Next. The federal court ruled that the divestment of the shares in PEB were in the best interest of the company for proper purpose and in good faith, and there was no evidence that the director acted in breach of their duties. Since the director can be proved that they made the decision to sell off the PEB share owned by PBB for the best interest of the company for the proper purpose and in good faith, there was no evidence that the director acted in the breach of their duties. There no sanction given by the court. Next. So this is suggestion for the director, what the director should do. So in this case, the director actually are not breaching any of their duties. It is because the majority of the PBB shareholders as a plaintiff in this case may not know or understand what is the best course for the business moving forward due to not being actively involved in making business decisions and lacking true understanding of the business process. So the acts and procedures can be done to prevent as follows. Firstly, to the shareholders of PBB have no authority to take away the powers of the board of directors. Next, the director also as an agent must exercise reasonable care, skill, diligence, and knowledge and experience, which may reasonably be expected for a director having the same responsibilities. And other than that, in this case, the directors had made his own business judgment with his experience and obtained legal advice and opinion from the other professional firms such as Fin Investment Bank and TA Security Holding the Part to make sure that the company can keep existing resources in hand. And the director maintained proper record they informed about the company financial situation and ensuring that the company complies with the applicable law and regulation. And lastly, the director also have disclosed all the relevant documents that related with the transaction of selling the PEP shares to every relevant party, including the shareholder. The decision to sell the PEB share was done by all the board of directors in the general meeting. Next, I will pass to Atila to conclude the presentation.
Next. So for the conclusion, we concluded from this case that there are actually numerous lessons to be gained from either the young directors or the young secretary's perspective. So for the young director, firstly, even though the shareholders has the right to question, comment, discuss, and make recommendation on the management, the director still has a huge power in managing the company and free to decide anything for the best interest of the company without oppress the right of the shareholders relevant to the Section 346 Companies Act 2016. And the second one, the shareholders cannot interfere with the business decisions of the company made by the board of directors. This effectively means that even if shareholders pass resolution at general meeting of a company that have an effect on the business decisions, the BOD are not restricted by those resolutions. They are still possess the ultimate powers to make the business decisions of the company, subjected to the duties of the director to act in the best interest of the company. And next, the director should bring the issue of selling the entire PEB share to the annual general meeting to include the shareholders' opinion and prevent any problem with their shareholders. So basically, the director can explain the solution chosen for selling the entire shares in the PEB and negotiating with them to prevent any internal conflict arise. And also the director should educate themselves on the operations, finances, and legal requirement of the company to enable them avoid failing in their duties. So the directors can make sure that they are upholding their obligation to the company and its shareholder by using the guidance provided. And lastly, they ought to learn the value of independent advice by consulting the independent lawyers and accountants before making significant decisions, so that this can prevent them from misinterpreting any company legal requirement and from being held liable for action that they actually did not take. So that's all from our group. Thank you.
Thank you very much. Go back to your slide. Go back. Lagi. Okay. Now tell me, what is AA, Article of Association? No, you don't have to tell me. Let me explain. Let me share with you. Do you remember that I said we have Article of Association and Memorandum of Association? We do have much earlier, before 2016. After 2016, we do not have Article of Association, Memorandum of Association. We have Constitution. Okay? Look here. The director were accused for breach of duty to act in the best interest. By the way, I tell you what, Attila, you guys did a great job. I like your presentation. You give a lot of input here. I just want to extend your presentation and give some further input, all right? So all of you listen here. They were accused for breach of duty because it says that they make a decision that caused the company to suffer loss, right? But then another issue is that the shareholder tried to restrict them. Okay, and the question is whether the shareholder can restrict their action, you know. You see, the court says this: shareholder in general meeting cannot deduct the power of management conferred by AA. The court basically says that if your constitution give the directors power, shareholder cannot limit the power. If shareholders want to limit the power of director, you have to amend your constitution. Here they use the word AA, right? I told you earlier we call Article of Association, Memorandum of Association. Now it's constitution, right? So the court said that you want to limit the BOD power, can, but you amend your constitution first. Your constitution already give power. You see, if the constitution give less power, then the directors must listen. But the constitution give a lot of power, all right? And then here, see, BOD's management function are granted by the constitution to it. Therefore, the shareholder cannot control them in a general meeting. Shareholder can control if constitution give less power. Okay? All of you, are you listening? Right. Now, next. Next slides, please. Next, I see that they got, no, before that. I see that they got advice from bank before they make decisions. So can you go back one more slide, please? Before this, please. There's one slide that you says that the BOD got the how do I say, advice from trust and bank something just now. That slide I want to see. Yes, maybe this one. Look here. You see, before they make decision, the fact is this. They want to sell the shares and the shareholder try to limit them, but they cannot be limited by the shareholders because the constitution gives them big power, huge power, right? And before they make the decision, what they did, due diligence, I mean, they did not breach their duty of care, because what they did is that, first of all, they go here, Affin Investment Bank, NTA Securities Holdings Berhad, get professional advice. They obtain legal advice, they obtain professional advice, and then they sell the shares, you know? So they make their homework. They act with skill, diligence, and reasonable care. And they have power. You see? That's why they are not liable, because they follow the law. We have which section that state that you cannot make the directors liable if they follow all these rules. Which section is that? You find out. Okay? Thank you very much. Good job.